Our Region's Business is sponsored by PNC for the Achiever in You.
Gone are the days when the telephone was the primary social medium. Today we live in a Wi-Fi world full of tweets and likes, Instagrams and Pinterests. The instantaneous flow of information can pose its own set of problems for individuals and their employers. Allison Feldstein and Ryan Siciliano are here with a few tips on what's at stake and some advice on what to do about it. Allison and Ryan are partners with Eckerd, Siemens, Sharon and Malott in Pittsburgh. And welcome. Good to see you. Thanks for coming out.
Thank you.
This is a fast evolving area, I guess, of employment law. It seems like every time I turn around, there's some new announcement or finding or whatever happening in the space. Why don't we talk a little bit sort of the different phases, I guess. This is when you're looking for a job, there's aspects. When you're working, there's aspects and other. So what are some of the issues that are arising in that sort of pre-employment process?
Well, I think both employers and employees have to be aware of the social media aspects and what's going on out there in terms of the pre-employment phase. A lot of times now, employers are looking to Facebook, looking to Twitter, looking to these social media sites to gather information about applicants for employment. And there are a couple of things employers need to be worried about and employees as well. From the employer perspective, obviously there are various laws out there that protect employees from employers using information at the pre-employment phase.
Like discrimination issues and whatever else?
Exactly, like discrimination issues. So you can't ask an applicant about how old they are. You can't ask them their marital status in certain states.
So if that's the kind of stuff you're doing this search, you're trying to find out more about this person, you would just stumble into the fact that the woman's pregnant. Are the guys a lot older than maybe you had suspected?
Exactly. And the concern is that you're going to actually be accused of using that information in making your hiring decision. So I think employers need to be careful in seeking that information at the pre-employment phase because they don't want to be accused of using it later on down the road in making the employment decision. So that's kind of the big pre-employment piece.
Okay, different story once you're actually working. You got the job, you're working for the company, and it sounds like you're kind of protected while you're looking for a job, but there may be a different set of rules once you're actually an employee?
There can be. There are implications both for the employer and the employee. One of the things we often see is questions from employers dealing with how do we respond if an employee posts something that we don't necessarily like? We don't think it's appropriate. Can we discipline that employee? And it's interesting, the law that generates a lot of the cases in this area is the National Labor Relations Act, which ordinarily you think union employees. I don't have to worry about that unless I've got a union, and that's not the case. In a nutshell, what that law says is, look, employees have the right to gripe about the workplace. They can.
Great, just what
everyone wants to hear, right?
Yeah.
You know, they can express their opinions about their working conditions, and so the real challenge for employers is knowing whether that particular post that pertains to the workplace, does it rise to the level of a protected activity such that you got to be careful taking action, or you might run afoul of the act.
It'd be like the water cooler conversation.
Exactly.
Bunch of employees get around, they start griping about the boss, they don't think they make enough money, but they are legally allowed to have that conversation, right? That's playing out online, there's actually some protection for that.
Correct.
There can be, that's right.
Now there are limits to that protection as well. So, employees can't engage in behavior that would rise to the level of what would be considered disloyal behavior, disclosure of confidential information, harassment, that type of thing. That type of activity is not protected. So there is a line that can be drawn there.
And that's the challenge. Where does that line lie? And that's some of the struggles we see that employers are having.
And they really have to be careful in how they approach that. Well, what happened to the First Amendment in all of this? I thought, you can stick things on poles over towns, an old-fashioned leaflet or whatever. Or don't we live in an era now when it's digital leafleting? Aren't we protected?
That's sort of one of the myths that's floating around out there that, hey, I have a Facebook page. I'm going to post to that page. And if my employer wants to take any action against me because of what I posted, that's a First Amendment issue. I've got a right to do that. And the reality is you probably don't for a whole host of reasons, one of the primary ones being unless you're working for the government, unless you're what's called a state actor, your employer is not in a position to violate your constitutional rights. They're a private entity. So that notion that, well, the First Amendment's going to protect what I put on my Facebook page, in most cases, it's not applicable.
So that could apply to both posting company secrets or company information, but even if you engaged in conduct the employer felt put the company in a bad position because it was immoral or whatever else, the company actually has standing to limit your behavior.
That's right. Unless, of course, going back to what Ryan said, it would violate the National Labor Relations Act in those discrete circumstances. But yes, an employer can certainly take action.
Wow, fascinating stuff. Any other thing people need to be aware of when they're thinking about social media before they hit the post button the next time?
I think it's really you need to recognize what your rights are and what can and can't be viewed. And in most workplaces, if you're on the work computer, there's probably a policy that says, hey, we've got the right to monitor this, and we will monitor it, and you have no expectation of privacy. So you need to understand that both as an employee and as employers, you should be prepared to have those in place so you can monitor your workplace.
Really speaks to the importance of a really clear guidelines for how you operate.
Yes, and we always counsel employers to make sure that they have very comprehensive social media policies, internet usage policies, email policies, so that employees know exactly what to expect.
All right, great words to the wise, fascinating area in this era. Allison Feldstein and Ryan Siciliano from Eckerd Siemens. Thank you both so much.
Thank you.
Thanks so much.
Yeah. And we'll be back in a minute with little dollars and cents. Stay with us.